Thank you, Senator Booker. I will say that artificial intelligence has gained a lot of attention lately, over the last year and a half or so in particular, but the core technology has been around for some time. Because of how it's depicted, maybe we should start with what it's not. Many people, fortunately most people, don't have much personal interaction with law enforcement or with the criminal justice system. What is AI in law enforcement not, though? It's not RoboCop, it's not the Terminator, it's not the Matrix, it's not Ultron, it's not even Wall-E. It is never used independent of human decision-making in our criminal justice system. That's why it's a tool in the law enforcement toolbox, and it can provide impressive time-saving and crime-solving and justice-serving tools. Just one example, facial recognition software, for instance, could take a crime scene sketch or a security camera image and go through thousands and thousands of pictures in a public database, say a driver's license database. It can eliminate obvious non-matches. It might be even to narrow it down, but then that is a tool that independent human judgment can use to pursue leads. If the early stages of a criminal investigation are like looking for a needle in a haystack, then artificial intelligence, if you will, can provide a magnet for some of our criminal investigators in the police forces around the country. That's why I want to enter into the record with consent here a statement from the National Sheriff's Association, the major county sheriffs of America, and the major cities chief association. They represent state and local law enforcement all across the country. I want to highlight one particular line from their statement. Quote, "It is essential to recognize that AI-powered technology serves as an investigative assistant to law enforcement rather than a replacement for the human element," end quote. Mr. Chairman, I ask consent to enter that statement into the record.
Without objection.
I also want to give one concrete real-world example of how this can work. Last summer, British authorities contacted the Department of Homeland Security about a video of child sexual exploitation. They had reason to believe it was made in the United States. DHS ran the faces against a mass database of photos, and they found a match, a college sports administrator in Missouri. Investigators then found the suspect's Facebook profile and were able to confirm not only that it was the same person, but even that the child victim was on his Facebook page. They eventually got a search warrant from a judge, and in July they were able to arrest and charge this predator. Without that facial recognition technology, he might be free today, and that child might still be subjected to abuse today as well. AI-powered law enforcement tools also improve efficiency and save lives in other ways. For instance, by modeling where and when crimes happen, law enforcement agencies can better position limited patrol units to prevent crimes or to respond quickly. They can coordinate with other emergency services like ambulances for better staffing at times and places where they would be needed. In yet other cases, AI-powered products like those made by Motorola Solutions are used by 911 call centers to clean up, transcribe, and even translate 911 calls in real time. Or an AI product made by the company Axon is used by law enforcement to quickly blur faces in body cam footage so police departments can share the footage with the public faster. Other AI-powered tools can analyze financial records to help identify financial crime. And AI-powered cameras can recognize license plates of wanted individuals and alert law enforcement to investigate. Now, I understand there are some who have concerns about the use of artificial intelligence technology in law enforcement, and those concerns are in some cases valid and should be aired, which I think we'll do today. But I do want to point out that probably the most uncomfortable people with the use of artificial intelligence are criminals who would like to avoid being caught. Because again, artificial intelligence is simply a tool that human investigators, police officers, prosecutors can use to help solve cases, convict criminals, and put them behind bars. We need to remember that artificial intelligence-powered law enforcement tools are assistive technologies, helping law enforcement officers be better at their jobs. And responsibly used, these technologies can help create a faster, cheaper, more accurate criminal justice system where the criminals are being caught, prosecuted, victims are being provided justice, and the innocent are not being punished. I know our witnesses have thoughts and expertise to share on these questions, and I look forward to today's conversation. I do want to say and apologize in advance that since this hearing was scheduled, the Republican Conference has scheduled an all-Republican meeting about the National Security Supplemental Bill that is currently under debate. So I may not make it to the end, but I assure you it has nothing to do with your testimony. Thank you all. Mr. Aguilar, you mentioned in your opening testimony that tip lines like Crime Stoppers. You'd also said last year in an interview that your department treats facial recognition technology, quote, like a tip that is called into Crime Stoppers. Is that correct? Do you recall that?
Yes, Senator.
So in your career as a police officer, have you ever gotten erroneous tips from Crime Stopper hotlines?
At least tips that we couldn't corroborate with other evidence. Absolutely, Senator.
Okay. Have you ever considered eliminating Crime Stopper hotlines because you get erroneous tips?
Absolutely not.
Okay. You're not testifying that, say, facial recognition technology or ballistic technology is flawless, are you?
I'm not.
Okay. Let's say that you have facial recognition technology and you run a security camera image through that technology and it gives you back 7 potential positives. What's the next steps do you take? Do you go out and arrest all 7 individuals?
Absolutely not, Senator. We would treat the matches as if we had just received 7 Crime Stoppers tips, and our detectives would do their due diligence and either try to discount or corroborate it with other evidence that could tie that person to the crime scene.
Using other technology or even artificial intelligence technology, or using traditional gumshoe investigative techniques?
All of the above, Senator. This is absolutely not a substitute for traditional investigative methods. It complements traditional investigative methods, but in no way can AI, at least in my view, substitute traditional methods.
Okay. What would be the consequence if you did not have this kind of technology in your department?
I'm very certain that we would have many more crimes that would go not only unsolved, but there's an additional consequence to having unsolved crimes, and that is that those criminal suspects are allowed to continue to victimize other people. And so it's not just a lower clearance rate, but it's also a higher victimization rate.
Okay. Ms. Wexler, one of your chief points seems to be that the vendors who provide such technology should be compelled to disclose their source code. Is that correct?
If the source code is relevant evidence in a particular case, then that should be the baseline standard and it should be disclosed under a protective order that protects the intellectual property interest to the reasonable degree.
Could you give examples again of when that would be relevant evidence? Because as Mr. Aguilar said, if you get 7 positives from facial recognition technology, that itself is not going to be what cinches the case or gets a conviction or perhaps even admitted into court. It's going to be the follow-on investigative techniques that his detectives use. Sure.
So relevance means any evidence that makes a fact at issue in a case more or less likely than it would be without the evidence. So it's actually a pretty low bar. I tell my students a brick is not a wall. So evidence doesn't have to disprove the whole case in order to be relevant. It just needs to weaken or strengthen one element of it. So any information about how a forensic technology works that could expose unreliability of a particular match would be relevant.
Let's use something a little more high-tech than, say, facial recognition, which we all engage in every single day. Let's say ballistic matching. If you have AI-assisted ballistic matching, is that the source code of that technology, is that what's relevant, or is it going to be the testimony, the human testimony that follows on that, presumably from dueling witnesses the state uses and that the defense uses? Why does the source code matter once you have those dueling witnesses in the follow-on question?
So various aspects of the technology might be relevant in a particular case. The source code might not always be relevant, but it could be in a particular case. Even if an AI technology is then being reviewed, the conclusions are reviewed by a human witness, the AI results may have biased the human witness, so it would be important to understand if they were flawed. AI results may, in face recognition technology, produce alternate candidate lists that could be exculpatory evidence that would need to be disclosed to the defense. So those are examples.
Why do you think these vendors don't want to disclose your source code to you and your fellow law professors or to criminal defense attorneys?
So to be clear, my fellow academic researchers and
y'all wanted a license. Why do they not want to give you a license to use it, and why do they not want to disclose it to criminal defense attorneys?
My personal view, and of course I don't have insight into their own heads, is that they are concerned about subjecting their products to robust adversarial scrutiny because that scrutiny might expose weaknesses or flaws in their tools.
And these products have undergone testing by, say, our our own Department of Justice, haven't they?
Some of the products have undergone testing and some of them less so. So in terms of probabilistic genotyping software programs, again, the GAO office, NIST, the PCAST report have all identified concern that much of the testing was not performed by independent researchers. And most recently, NIST identified that some of the published studies, validation studies, don't have enough publicly available data to be independently verified.
Mr. Aguilar, do you have any thoughts on why these vendors might not want to disclose their source code to criminal defense attorneys or provide research licenses to professors?
Senator, I cannot speak for the vendors. I can only imagine that there's at least some concern over intellectual property, but I certainly cannot speak for the vendors.
Okay, and Ms. Wexler, you keep saying protective order. There you're talking about disclosure of source code in a criminal proceeding, right?
Could be disclosure of any aspect of the technology. So vendors, these companies have actually alleged that trade secret privileges should apply to all sorts of aspects of these tools, including things like user manuals. So it's not limited to source code. But I will say that, you know, courts order disclosure of intellectual property under protective orders, reasonable protective orders all the time. It's a common solution in civil cases, and if it's effective there, it should also be deemed sufficient in criminal cases where the stakes are life and liberty. And I'll add that protective orders give intellectual property holders more safeguards than the non-disclosure orders that companies usually, non-disclosure agreements, that companies usually disclose the same information under for when they share it with their employees or with business negotiators. So the protective order, if there were to be a leak, rare instance, there's not evidence that protective orders are generally violated or commonly violated, but in the rare circumstance where that might happen, a trade secret holder would still be entitled to sue for misappropriation of their intellectual property. And on top of that substantive trade secret guarantee, there would be the additional guarantee of criminal or civil contempt of court, plus the possibility of disciplinary sanctions if it were an attorney who violated the protective order. So given those safeguards, trade secret law does not provide a good reason to withhold relevant evidence in a criminal case.
Mr. Aguilar, in your long history of criminal proceedings, has a protective order ever been violated?
No instances come to mind, Senator.
Okay, thank you.